to write in praise of litigation.
So can everybody hear me with the mic? Great. I've been teaching civil procedure for 13 years, and before that I was a litigator. And the reason I wrote the book is because I wanted to assign a book to my students that would make the case of why litigation was an important social good. And so I went to look, I thought, well, somebody's written this, and so I went to just look for it, and I couldn't find it anywhere. There are a lot of very accessible, although I would say not well-reasoned, books against litigation. One of them is even a New York Times bestseller, but there wasn't anything on the other side. There's some books in defense of the tort system, but not of this social institution as a whole. And so that's why I wrote it, because I felt like nobody was making the argument about why this is a good from a democratic point of view, and that's the argument I try to make in the book. I try to show what the benefits of letting people have access to the courts are. And I think especially now, and Deepak and I were talking about the vote last night in the Senate, so I'm sure we'll get to that, but especially now, I think, when our access to justice is really under assault from so many different directions, it's worth thinking, well, why do we let people sue? You know, are all the people that sue really bringing frivolous claims, and what's going on? And I try to look into those questions in the book, and also think about it from a broader theoretical perspective as well.
So one of the things that was interesting to me about the book, and as you can see, there were a lot of things interesting to me about the book, but you actually take the time in this book to not talk about the good of litigation in terms of winning or losing a case, but just what the process of it brings to democracy and to American society. Would you mind talking about just a few of the principles that you feel like are really important about our litigation system?
Yeah, so first about the process point. So obviously I teach procedure, so I'm all about process. But I think we too often, you know, when you think about litigation, a lot of times, especially if you're not a lawyer, you think, well, it's a dispute resolution mechanism, right? It's a way to resolve disputes, and that's obviously an important goal. And then you think, well, if I'm suing, I want to win. You know, that's a normal, I think, human feeling. But what I try to show in the book is that it's not just about winning, though it's nice if your side wins. But it's also about the things that happen on the way to the end point. And sometimes we even have situations where people lose, but the loss inspires other people to say, you know, that was wrong what happened to that person, and we can't let that go forward. So the principles I talk about in the book are first, enforcement of the law. Litigation in the United States, because we have such a relatively thin regulatory framework here in the US, litigation is one of the ways that we enforce the law. Now, that's not to say that we couldn't do it other ways, so we could adopt a more European model where we would have much stronger regulation. But we, for historical reasons that we can get into, have chosen to really devolve enforcement to individuals. And that's sort of consistent, I think, if you think about kind of our overall what we're like as Americans. We're kind of individualists, and we like individual independence. And so the idea of devolving enforcement to the individual level kind of sits well with these other bigger themes of our political life. So one reason is that we have litigation is to enforce the law. And really it has two components that I talk about in the book that I want to highlight for people because I think they're important, and because it gets also to your point about winning. So one thing litigation does is it requires the other side to answer. And there's very few other areas of life, of social life, where you can actually force somebody who you think did you wrong to be required to answer and say, you know what, I didn't wrong you. What you think happened isn't what happened, or what you think happened is what happened, but the law permits it, or whatever the response is. But that's a very important feeling, I think, for people to have, that they actually have a recourse to something where a neutral arbiter will listen to their claim, and then their opponent will be forced to say, this is my response to that. And the second is accountability. That's the winning part, right? So if you can hold somebody accountable, we hope that in the future it will prevent other wrongdoing. The second principle is information forcing or transparency. So there are lots of stories, and we can tell some of them if you want during the Q&A, of people bringing lawsuits, and the process of bringing a lawsuit revealed information about what was going on that otherwise would not have been produced, and we wouldn't know about it. And furthermore, there's a lot of cases, and in the book I use the example of the NYPD, the New York City Police Department, where institutions will actually keep information because they're worried about litigation. And we can then use that information, litigants can use that information to study those institutions and to say, well, you guys have been filling out these forms every time you stop somebody, and it turns out that you're disproportionately stopping Blacks and Latinos in New York City. And it turns out that you disproportionately, your reason for stopping them is furtive movements, right? Which is a very difficult thing to pin down in terms of, is that really a valid constitutional reason to stop someone? And that can start, so in that case, it started a litigation, which ultimately led to changes in the New York City Police Department. But it was because of that information that people were able to argue. You can't hear? Oh, sorry. I'll try again. Can you just raise your hand if I'll pick on you to be my canary in a coal mine? At any rate, it was a fascinating in history, this idea that we can pull out all this information and then figure out, is racial profiling going on or is it not? And if they didn't keep that information, which they did to protect themselves from litigation, we wouldn't know what the underlying facts were. So that's the second thing. The third thing is participation, that litigation allows individuals to participate in our own self-government. I think the poster example for that would be Deepak's emolument suit. So the idea that we as citizens can come forward and say, I think this is wrong, and I want to have a conversation about whether this is wrong and why it's wrong. And then the final principle, which is, I think, adhered to more in the ideals than in reality, is social equality. And so by that I don't mean fiscal equality, like that we all have the same amount of money, because we never will, but rather the idea that we're social equals to one another, and that even the most powerful person can be called into court to answer for what they did or failed to do. And that's, that's true also for a powerful person going into court and saying, hey, I was wronged. But that's a really important ideal. So even above the Supreme Court, it says equal justice under law. Now, I don't know if you guys know this, but that is not in the Constitution. That was the architect of the Supreme Court building in the 1950s, and he thought, wouldn't it be nice to have this statement up there? But it really does speak to people's ideals of what our justice system is supposed to be like. It's supposed to be a place where somebody who's homeless, I can feel myself going on. Somebody, how's that? Good. Somebody who's homeless, somebody who is maybe, not deserving of the kind of admiration that we might otherwise give, but still, they're entitled to come to court and to say, but my rights were violated. I'm an equal citizen to other people, and I have rights that I can assert. And that comes from a very fundamental idea that I first encountered in Hannah Arendt's work, which is the right to have rights. That the most fundamental thing about being a citizen of a place is that you have a right to assert your rights. Now then we have to ask, well, what are those rights? And do we have enough rights or too many rights? And we can have that conversation. But the first thing has to be, I'm entitled to assert my rights. And what's scary is the way in which in the last 30 years, we as a society have eroded people's ability to even assert their rights. Never mind that the actual rights themselves have been eroded. You can't even argue in court, I have this right. And that is incredibly troubling, and I hope we'll discuss that a little more today.
I bet we will. So I talked earlier about some of the grants that the Impact Fund has done, and the ones that I was thinking about reading your book are grants that we've given in cases defending the rights of foster children to be protected from abuse in the system, or the rights of prisoners to have suitable living conditions. And so these are people that if we did not have a court system would not be able to voice their rights and have themselves prioritized in the democratic system because they can't vote. So without that, they would be completely silenced. So litigation really is the main way that people that otherwise can't participate in the democratic process can be fully present and make their voices heard. And that is also very much a theme of your work, Deepak. So could you tell us a bit about what brought you to civil rights law in general, and then also specifically the emoluments case, which you argued last week?
Yeah, sure. So first, I just want to say thank you to the Impact Fund for organizing this conversation. It's an organization that means a lot to me, and as Lindsay just says, what's great about the organization is that it makes cases happen that might not otherwise happen by identifying needs and then making grants. It does a lot of other things too. It trains lawyers to do this kind of work. So it's concerned with the infrastructure of litigation. And I also just want to say, I'm excited to talk about Alexi's book, because I too had the experience of not finding a book like this out there, and was sort of surprised that there's all these attacks on litigation, but there isn't. There not only was there not just sort of a popular defense making the kind of political arguments, but there wasn't anything approaching a kind of political philosophy of litigation, which is, I think, what you're gesturing in the direction of, and I think it's great. So just a little nutshell version of how I ended up doing what I'm doing. So I think a lot of people that do the kind of work I did, I realized at some point that I really liked making arguments and was interested in philosophy and debating and stuff like that. But you can sort of interminably debate, what's good and what's just. And people do answer those arguments, but the difference is nobody decides who's right and does something about them, and in a way that has an impact on real people's lives. And to me, what attracted me to the law, and particularly to public interest litigation, was the ability to, you can actually write something down on a piece of paper. You can write an argument, and instead of it just kind of floating into the ether, or maybe somebody will read it, somebody has to respond to that argument. Somebody has to decide that, and there's just a real pull to people who think a certain way, a real attraction to that kind of work. So, I think for a lot of people, my conception of what public interest law meant when I was, in college or going to law school was pretty narrow, and I knew about Brown versus Board, I knew about big sort of constitutional social impact litigation, right? That was, so I thought of traditional civil rights and civil liberties litigation as what I wanted to do. And I'd kind of taken a circuitous path in law school. I did that. I worked at the ACLU doing prisoners' rights. I worked at the voting rights section of the Justice Department. I worked for an organization called Americans United for Separation of Church and State, doing religious liberties cases, a bunch of different kinds of civil liberties and civil liberties things, civil rights and civil liberties things. But after I clerked, I ended up in an organization called Public Citizen that has a much broader conception of public interest law and works a lot on some of the stuff we'll be talking about, the nuts and bolts of what makes the litigation system function. Questions like whether people get into the courthouse door at all, whether big companies can write contracts that stop people from getting into the courthouse. And I became a lot more interested in those questions, and those are the kinds of questions I've really focused on, rather than just kind of the substantive law in particular areas. And I was just really, really fortunate to be in a place where people thought very creatively about the law, and some of these folks, they're just really great lawyers and teachers, and they're very excited about litigation as a site to make things happen. You could read something in the newspaper that you didn't think was right, and you could turn that into a case. And it was just a really amazing place to work and really amazing lawyers to work with. And so I ended up doing that and thinking that I would just stay there. I was doing consumer rights cases mostly. I ended up arguing a case in the Supreme Court about whether companies could use the fine print of their contracts in clauses called arbitration clauses to prevent consumers from banding together and getting to court. I lost that case 5-4. It was a case called AT&T versus Concepcion. And then after losing that case, right around that time, this person named Elizabeth Warren, who was a law professor, had designed the idea for this consumer watchdog agency. And just the idea of being able to work for her and build this agency and build its litigation program persuaded me to leave Public Citizen. And then after that was launched, I decided one startup wasn't enough, so I started my own firm. And I'm doing what I'm doing now. It's not just emoluments. It's most of what we do is cases about access to justice, class actions, consumer rights, workers' rights. It's a really broad range, as you mentioned in your intro of some of the cases we've done. If you had asked me what the emoluments clauses of the Constitution were around this time last year, I'm not sure I would have been able to give a coherent answer. Probably not.
I think that holds true for most of us.
So, but just to filter this through, Alexi's book, I mean, we all have this sense that there are some troubling things happening, right? We have this sense that maybe our country's leaning towards kleptocracy, there are some conflicts of interest here, and those problems are broader than just what the emoluments clauses are about. But one of the things that happens is that the law kind of narrows and focuses a problem, a real-world problem, because it becomes narrowed into a legal problem. And that's the case with the emoluments clause. There's a constitutional provision. The framers, in their infinite wisdom, foresaw the risk that somebody would be elected and would try to profit off of the office and do so by taking payments from foreign governments. And that becomes one lens into which we can have a debate about Donald Trump's conflicts of interest. And the beautiful thing about our system is that we get to write up this document, a complaint. We file it in a court. We filed, this was a great feeling because we filed the case on the first working Monday of Donald Trump's presidency. So the inauguration was a Friday. So, we were all at the Women's March the next day, and we went back into the office and finished off this complaint, working with some leading constitutional scholars and ethics experts. And then the President of the United States, no matter how powerful you are in our system, you have to answer. I mean, yes, his lawyers answered them. I don't think he wrote these arguments himself. Actually, he pronounced the suit to be totally without merit.
Twitter?
I was doing an interview about the case that morning, right after we filed it, and I saw a clip of him saying in the Oval Office between signing some stacks of papers that the case was totally without merit. So he obviously had read it and processed it, and that's his only comment about the case. But he actually had to, in the litigation process, provide reasons. And one of the interesting things about that is that bad reasons can't hide. False facts can't hide. And that, the litigation process shows what the arguments really are on the other side. And in this case, you ended up having the Justice Department defend some very extreme propositions that despite this anti-corruption clause in the Constitution, the president's lawyer and the president's view is that he can accept all sorts of payments from foreign governments. And I argued this case in court last week in New York, and the judge had a really nice hypothetical that he asked the government's lawyer that illustrated the absurdity of this position. He said, if the president had a hot dog stand, could a country that wanted to influence the president's position on a treaty buy $1 million worth of hot dogs from him? Would that be fine? And it was a real problem for the government's position. That's just one of the great things that happens in litigation, is that we have this testing, through the crucible of factual and legal testing, bad arguments can die. The one example I like that Alexi mentions in the book is the Prop 8 case in California. And Kenji Yoshino, a law professor, has written about this. The very bad arguments against gay marriage rested on some empirical claims, and those could be tested in a trial, and they failed. They no longer could really credibly be made. And I think, society deliberates in all sorts of sites and ways, but this is one way that society deliberates about a problem. And so the effects of that kind of deliberation are much broader than just, the outcome of that particular case.
So in the current political climate, what do you guys see is the role of litigation? Is it broader than what you've talked about already?
Well, that's a hard question to access, so I'm just going to take it from one angle. So one of the things I like about what you said is that, and one of the points I try to make in the book that a lot of people, when I've spoken about it, have been a little bit resistant to, is that it's okay to think that consumer litigation is also really important, that it's not just this, not that civil rights, I don't want to diminish the import of civil rights litigation, but that consumer litigation, or some of the stuff you funded with in environmental law, that these are also environmental justice cases, these are also really important. And there's a really interesting book by a historian at Harvard called The Consumer's Republic. It's a little bit old now. But in that book, she says, look, since the 1950s, or even the 40s, the greatest contribution that you can make to your country is to buy more stuff. And if you look at there is some truth to that. And, the sacrifices that people make for their country are myriad, right? But one of the things that we're really encouraged to do is prop up the economy by buying a lot of stuff, right? And that's part of sort of being a citizen in the United States. And so that makes consumer protection really important. It's not a historical accident that in the 1970s we started to see the rise of consumer protection laws. And one of the reasons that there's been such I don't know if you call it a backlash, maybe it's just a lash, against litigation has been this idea that too many cases are filed, right? There's just this overabundance of litigation. And it is true that in the federal courts, at least, there was a real low ebb of litigation from about the mid-30s to the mid-50s. Now, if you think about what happened in the United States from about the mid-30s to about the mid-50s, right, we went through a Great Depression and then a World War. So people were too busy, basically, to be suing, and the economy was in a shambles. After the 50s, you start to see an uptick, and after the 64 Act, you see a real uptick in people bringing cases. Why? Because for the first time, they have a discrimination claim that they can bring. There was no remedy at law for being discriminated against in the way that we have today. And then so too you see with the environmental cases and the consumer cases. But that's not a bad story. That's a story of more people being able to say, I was wronged in this way, or my town was contaminated by this terrible, toxic waste, right? So in the example of it's not in the book, but I just read an article about DuPont's use of the chemical C8, which is a carcinogenic chemical. And DuPont knew for 25 years that this chemical causes cancer, and they continued to release it into the environment during that time. Why? Because nobody sued them about it, so they didn't have to release any information. So there are lots of stories, and I think what's interesting is to think about, well, when I think about rights that are important, what are the kinds of rights that I think are important? And do I need to rank them? Like, how should I think about them? And how should I think about allowing people to enforce them, right? And in our society, so much of what we experience is really as a consumer or an employee. Like, those are sort of, for most ordinary people, those are our two moments. And then for many people also, obviously, the criminal justice system, which is outside of our discussion here. But I think it's important for us to think about both areas, or all different kinds of areas in which we are participating as citizens, and where we feel like, well, they can't do that to me, right? And allowing people to make their claim with all those areas. So what's so great about the arc of your career is that it does tie together both what we think of as sort of traditional civil rights, but also these other social and economic rights that are also, I think, really important to people in terms of being a citizen in this country.
Yeah, I mean, it's in the name of this group, Public Citizen, that I mentioned that I work for, this conception of the consumer, consumer rights as an expression of citizenship. And I think, as public interest law has gotten more professionalized and segmented, we've moved away from that conception. But, I was definitely these paleo-liberal 70s types, raised by that, to think of all of this stuff as connected, and to think of, there are certainly public norms that are being expressed when you're doing a case about marketplace justice. We have a tendency to, I think that's right, when we're thinking about civil rights cases or cases against the government, it's very obvious, maybe less obvious when we're dealing with cases about marketplace justice. But make no mistake, what happened last night in the U.S. Senate. Can I just do a show of hands? How many of you know what the U.S. Senate, in some sense, the U.S. Senate voted on last night? Okay, so that's good. I mean, but this is, of course, a group of people that are here are interested in litigation. Because I was at an event this morning where there was mostly political reporters, and many of them had no idea. So the U.S. Senate last night voted to repeal a rule that the Consumer Financial Protection Bureau had issued that would have, within its jurisdiction, rolled back the effect of the Supreme Court's decision in that case I mentioned, Concepcion. It would have said that people can band together as consumers and sue banks. And in a vote of 50-50, where the Vice President of the United States had to break the tie, the Senate voted to allow that rule to be repealed. So there's your populist government in action. They are sticking up for the banks and not for the little guy, not for your ability to bring these cases. And of course, in many of these cases, if you can't band together and bring the claim in court, you're not going to be able to bring the claim at all. So, I think those kinds of cases, we should see those as political. We should see the debate about that as very much about, our expression of citizenship. You asked about, how we should see litigation in this political moment, and I think part of this political moment is we're so concerned about the erosion of all of these norms and what's happening. The news cycle is so exhausting that we can forget about these basic roles that we have as a citizen, as a consumer, as an employee. And I think the fact that last night's debate got so little attention, I was really alarmed. I mean, yesterday during the day there was all this focus on Jeff Flake, which was the latest story of the day, and very little attention paid to that vote until we lost the vote, and then suddenly it was breaking news. So I do want us, and I struggle with this every day, to try to remember that not everything is about Trump. That there are other problems in the world. They were here before Trump. They're going to be here afterwards, and they're important too. But I do think that let's face it, we're facing some real a test of our republic, and we're facing a norm-changing administration. And the value of litigation is not that it's going to fix the problem. The litigation is not going to erase the results of the election. Even my emoluments clause case is not, I'm sorry to say, going to erase the results of the election. What it can do is, I mentioned that we have this concern about conflicts of interest and kleptocracy, and you can have a constitutional conversation about that, and you certainly you can enforce those norms, but you also get all the things Alexi talks about. You get the transparency, you can get information about it, you can allow people to participate in it, right? All of this stuff has value. So we have this sense, I think many of us, that the administration is Islamophobic. It makes policy based on hatred of Muslims, based on hatred of other groups as well, xenophobia, racism. But the Muslim ban litigation, which was the litigation right out of the box as soon as the administration came into being, tested that. It didn't enforce a norm that says you don't get to be Islamophobic anymore. But the administration did come into court, and they had some claims, they had some arguments, and they said that what they had just done, the Muslim ban, was based on national security rationales. And those were exceptionally weak arguments. And they were completely eviscerated in the courts. I mean, the courts with incredible unanimity all around the country. Do you remember that weekend?
And rigor.
With rigor and unanimity and speed, shot the administration down and just showed that whatever else they were doing, it wasn't national security, that they had no credible national security rationale. And indeed, many of the courts came right out and said that the president, operating within the sphere of national security, was basing decisions based on animus. That has enormous value. Even if you aren't one of the people, why do we care about this so much? Even if we're not one of the people who are subject to the travel ban, we care about that because we care about this norm. We care about the idea that we live in a country where policymakers are not allowed to make decisions based on hatred of particular religions or races. And the courts stood up for that. And I think there was a real participatory aspect to that too. People were out at the airports, out at the courthouses. I've never seen people love lawyers more than that weekend. Right?
And probably never will again.
A lot of people probably hopefully decided to go to law school that week, But in a moment where we feel powerless, where we don't have any other institutions of government that we can turn to, the courts are available as a place where they're not going to solve these problems, but we can at least have a reasoned, it seems like there may be no other institutions where we can have reasoned conversations, but we can go there and have a reasoned conversation and find the facts. And that I think that does have an effect on whether these norms are going to continue to exist and be enforced.
So that weekend, I think, lives in all of our memories, both because, those images of the lawyers setting up stands in airports. I mean, it also sparked and continued on a thread of really beautiful and important public protests. So we had the Women's March, we've had Black Lives Matter protests. This is a really important moment where people are feeling the need to get out in the streets and speak directly to power. How do you see public protest and civil rights, consumer litigation in these moments? How do you see how they're related to each other, or are they?
Well, I mean, litigation doesn't happen in a vacuum, right? All litigation is part of a social context, and very few great litigation victories that achieve social change aren't also accompanied by mass movements. It doesn't happen without all of the tools being used. So, and I think public interest litigators get that. I didn't get that I read that, people had said that, but I don't think I really got that as a rookie lawyer. I think I've gotten that more over time and seen how that works. And also, I mean, let's be honest, and maybe this is a criticism of your book, Lex. I mean, you talk about litigation as participatory, but nothing is as participatory as protest. It's a raw expression of our anger as citizens, and we create encounters that where we participate directly much more than in litigation. And in litigation, there's a lawyer making the arguments for me. They're speaking a language I don't understand. It all has to get reframed in legal terms. And this is, when you think about class actions, to what extent are the people who are on whose behalf the claims are being prosecuted really participating or driving it, right? I mean, as public interest lawyers who represent communities, we have to make sure that we are making people feel involved in the process. We wouldn't have to do that if the process were sort of self-executingly participatory, right? So I'm curious about that tension.
So, it reminds me of Derek Bell has a very famous among law professors article, Serving Two Masters, right? It's about that conflict that he describes between, during the desegregation litigation between local families and the NAACP's integrationist agenda, which I found a very, mind-blowing thing to think about as a law student when I first read it. I think it's too common in critiques of litigation to say, well, where people should really put their effort and money is in protest and direct action, not in litigation, as though you only have, obviously money is limited, but it's not like, oh, either I'm going to do direct action or I'm going to do litigation. Litigation has a real, I think the biggest flaw is this narrowing that you mentioned earlier. So sometimes the legal test doesn't leave room for justice. And there's a question, how do you fit in to the, whatever the doctrine happens to be, how do you fit in the argument about what we really think is right and wrong, the norms, the justice aspect of it? And I think, when I teach my students, I say, well, look, that's your policy argument, now let's hang it on a doctrinal hook, right? There's always some way to do it, but you can see how people would find that disabling, right? That they say, look, I was wrong, and now you're telling me, like, emoluments, whatever, I don't know, like you're talking about some legal concept that doesn't really speak to the kind of wrong that I have experienced, right? Or you're telling me, it's limited, even though I know what happened to me, that I'm limited in all these ways by the kind of evidence that I can adduce, right, either in trial or even getting up to it. But I don't really, so that's a real flaw. But I think in terms of the either or, I think a lot of times it's the litigation that then empowers people to say, wait a minute, we should do something about this, right? So it's knowing that there's also a travel ban case that's going through the courts that inspires people to say, well, I should come out and support this position. Now, I'm sure you've all heard the statement, the Supreme Court follows the election returns. So you're not going to get federal judges, especially, to change, let's say something like arbitration, until people are really appalled. I don't know what's wrong with me. Deepak seems to have no problem. Until people are really appalled by what's going on, and I think arbitration is incredibly hard to access as an idea. It doesn't speak to any kind of visceral feelings about anything much. And so that's how a lot of the rights have been eroded over the last 20 years. It's through the uses of procedural mechanisms that leave your right intact, right? So you still have your Fourth Amendment right to be free from unlawful search and seizure, and you still have your right to equal protection of the laws. But I can tell you that it's going to be really hard for you to overcome the qualified immunity defense that they've created, and it's going to be really hard for you to get past the initial stage of the complaint because of new rules about how complaints are going to be read, and a million other rules like that. It's going to be very hard for you to get standing. You can't even go to court because they'll say, oh, were you actually injured by that? I know that you allege that you were put in a chokehold, but are you going to be put in a chokehold again?
That's a real case.
Are you going to be put in a chokehold again? Because I don't think you have standing to ask for an injunction to get the police to stop using chokeholds unless you can show that you are going to be put in a chokehold again. Now, who's going to be able to show that? Nobody, right? And those are all mechanisms for keeping people out of court so that it feels like you have the same rights in terms of, the Constitution hasn't changed, right? The Title VII hasn't changed, but the way it's interpreted is narrowed and narrowed until people have a really hard time getting access to justice. And that, I think, it's hard for people to access in terms of an ordinary person sort of thinking about. I can see how, if I were not a class action scholar, which, is maybe an embarrassing admission that I am, but I could see how you would look at class actions and you would say, look, all these lawyers are getting paid millions, and I'm getting like 50 cents or $1, and that's not right. You can see how people would feel that way about the process. And so they would say, so what? So you forced me to arbitrate? Like, I'm not in a different position. But the reality is that if you don't have any regulation, and then you also don't have any litigation, then there is nothing to stop Wells Fargo from creating a fake account in your name. And there's nothing to stop Equifax from, being a little maybe parsimonious in their hiring of people to protect your data. And there's nothing to stop them, as has happened in multiple cases, from including false data about you and then not responding when you ask them again and again, please, can you change this? Like, for example, I'll give you a personal example. The credit companies believe that I am my brother. So they have me as having an alias of my brother's name. The alias that they have, his first name doesn't even begin with the same letter as my first name. So it's like, why would you think that? And when I went to get a mortgage, this was an issue. People said, well, who's this guy? Who is your alias? Are you, this guy has a loan and that's you. And I'm like, okay, that's my brother. He has a home and he also has a mortgage, but it's not me. The process of trying to correct that is very difficult. That's the understatement of the century, right? It's very difficult. So the question is, well, what recourse do we have when our whole livelihood is at stake by whatever information they decide to include on this report, right? When our ability to vindicate whatever, pick your favorite right is limited. And in many cases, when you're talking about credit cards, this can mean the difference for people between staying afloat and going under, right? Between, everything going fine and falling into bankruptcy. And with the bankruptcy laws being even harsher now than they used to be, this is, that's what Elizabeth Warren works on. These are very difficult issues, and so that's why I get fired up about arbitration, because it's a systemic way to make sure that large corporations don't have to be responsive to their own failings. And it also, I think, rewards the wrongdoers at the expense of banks that aren't engaging in these practices. That is, if you can, as a bank, play fast and loose and increase your quarterly earnings, right, and do better on the market, then that's a good place to be. And if your competitor doesn't want to break the law, what's to stop them, a bad company or a company that's engaging in rough practices from taking advantage of their competitors in the marketplace? So there's lots of reasons why we want to enforce the law. This is kind of our way of doing it. It's through individuals. But you're right, the individual class members, their say is pretty limited. And there's lots of ways in which class action lawyers have started, and I think could do better, in reaching out to class members and communicating with class members, especially now with the rise of electronic media. So there's lots of things we could do better. I'm not saying it's perfect. But I think it's a mistake to say, it's either direct action or this crazy litigation process that I know nothing about. You can learn about it. You can make these arguments accessible. We're all talking about emoluments, for God's sakes. Right. Like, if we can talk about emoluments, I can tell you we can do anything.
So I'm always happy to talk about it. I can talk about emoluments all day. But, a lot of what you just said resonates a lot with me, and I have been trying, since working on the Concepcion case, even before that, to try to communicate the threat that forced arbitration poses to people, and it can be hard. I mean, it's an abstract noun. It's about a procedure. I don't think I'm ever going to need that. I don't plan to sue anyone. What's it to me? It doesn't matter to me. I think that's and I also think people tend to focus more on as you said, focus on the substance, rather than the procedure. I actually think that the Roberts Court knows that. I think that they know that they can take away rights more easily through procedure, and that people aren't going to pay attention to it. It's a huge decision last term that gutted people's ability to sue the federal government officials for damages. So like every case where somebody gets beat up by a federal officer is affected by this, and nothing, no press about that case. It just kind of escapes. And there's this quote that's attributed to former Congressman John Dingell. I think it's him. Yeah. That said, you let me, you write the substance, I'll write the procedure, I'll screw you every time. And I think there's a lot of wisdom in that. That the rules of the road are everything. If you don't have a means to get in the courthouse door and vindicate the right, what does it matter if you have the right? And we have had this kind of silent legal coup over the past few decades, where through a combination of Supreme Court decisions and the fine print that nobody reads in the contracts that nobody reads, where those rights, the basic rights that you thought Congress passed on your behalf, they've been silently stripped away. I'm kind of encouraged that things are changing a little bit, that this debate over the CFPB rule has changed things a bit. And it's interesting, people might not, arbitration might seem a little bit foreign to them, but they do get that they should have rights, and they don't want those rights to be taken away on behalf of banks. They don't like the idea, across the political spectrum, they do not like the idea that their government is taking away their legal rights to protect banks. And so if it starts to get framed that way, I think we have some possibility of making some real progress on this. It's also interesting to me that in these, the debates about this issue, you think about why arbitration is objectionable, you start to articulate the very values that you've identified in your book, right? So, we like the litigation system versus arbitration because it allows us to get the facts and discovery and make them transparent. It's not confidential. We like, precedent and equality of outcomes. We like that it has all these processes and that it can uphold public norms. So you start to paint this picture through that debate of what the values of litigation really are. I was wondering if that maybe is partly what animated your book. But
the arbitration debate?
Yeah.
I mean, it's part of it. It's law professors have been obsessed with it since basically, when was Concepcion, 2011?
Yeah.
Yeah, so it's something, since that case, people have been really thinking about it. Yeah. One of the really interesting things about arbitration is that when you move litigation into a private system where the repeat players are the more powerful, the studies indicate, so there's some really interesting qualitative studies where people have gone in and seen, well, how does a rule evolve once something is moved into arbitration? So there's a professor at Irvine who did a study of lemon laws in California that were moved into an arbitration system. And what you find is that the repeat players, in this case it was the car manufacturers, they shift the rules to benefit them over time. And the arbitrators go along with it because that's where their business comes from, right? The difference between an arbitrator and a state court judge or a federal judge is that the federal and state court judges are paid for by all of us. They're a public good. The arbitrator is paid for by the people in front of him or her. That's who pays their salary. And that's a really big difference. So if I know that if I make a good decision, well, you'll keep coming back and giving me your business, even if you questioned me, even if you gave me truth serum, I wouldn't admit it. But at some level, that's what's happening, right? Whereas a federal judge is paid for out of the federal fisc. And I think they do feel, even though, they've done some things that I wholeheartedly disagree with, I do think they feel an obligation to be an unbiased arbiter and to follow the law. Judges. Yeah. In a way that arbitrators really don't. And so part of what businesses, I was talking to a guy who's an assistant GC last week, and he said, what we like about arbitrators is that they don't need to follow the law. He wasn't talking about consumer cases. He was talking about arbitration between two companies where, have some deal that fell apart. He's like, we like it that they don't follow the law. They just split the baby every time. And I was like, well, that's really interesting, so it limits your risk. I can see why you would like that. But you can also see how, as a consumer, you wouldn't really love that, right? To say, well, I don't know who's wrong or right, but you get $10. It's like, well,
the least empowered person in that equation is the consumer or is the individual. They're the only ones that are not going to show up again, so there's no incentive to help them.
Right. And federal judges that I've talked to take really seriously the person in front of them. Maybe I talk to only a select few, but they do take that very seriously. So in the Second Circuit, which is the circuit that I teach in, they let pro se litigants do oral argument, because they care about people. I think that really says
Yeah.
something about them and their values.
And that's a
really
recognition
positive.
of the participation.
I'm going to interrupt you guys just really quickly to say, if anyone has questions, to write them down on the cards and make sure that they get to Chanel's in the back, raising her hand. Chanel, if you wouldn't mind just moving up a little bit, and so anyone can please jot down questions for our guests and give them to Chanel. I don't know if Kanisha or Madison, are you in the room? Kanisha or Madison? Okay, great. Chanel's on point tonight, so please make sure your questions get to her, and we will start answering those in just a minute or two.
Can I ask a question?
Of course.
So this is a question for Alexi. So I've been thinking about how, and I don't know if your book addresses this, but in the arbitration debates, I think that there's sort of like two kinds of cases. And there's one kind of case where, like, I ordered a widget and, the widget it was broken when it got here. I didn't get the widget, or like, I don't know, you and I have a contract and you broke the contract, and like, we just got to figure out who broke the contract and what the damages are, right? That's one kind of case. And then there's another kind of case where there are public norms and where all these values that you talk about matter a lot more. Those are the cases that are class actions, where we have federal statutes, where, and you mentioned in your book, like, contract cases are a lot of the cases, but I really think your framework is more focused on, these kinds of cases. These are the cases we've been talking about, civil rights cases, public cases, and I just wonder if part of the debate about this stuff is that people are talking past each other, that the people who are, supporters of arbitration, they have the conception is, it's just about resolving this dispute, it's just about the widgets, and then over here you've got, people who are trying to
so we
think
know,
about
right,
public
that
norms,
arbitration clauses are found in a lot of employment contracts, and they limit people's ability to bring discrimination claims. The sexual harassment stuff that's been in the news, right? That's all arbitration clauses and secret settlements. That's what keeps those things under wraps. And I think most people would agree that's a civil rights kind of issue rather than a contract issue. I just want to say in defense of contract that, so in the state courts where most cases are heard, so 17 million cases are filed every year in the state courts, between 40 to 80% of those, depending on the state, are contract actions. So they're your contractor didn't finish the job, so you're suing them, or, widgets or what have you. I don't talk much about those cases because they're not controversial. Nobody's saying, hey, people shouldn't be allowed to sue in contract. Yet they're saying people shouldn't be allowed to sue in tort. People shouldn't be allowed to bring civil rights suits. There are too many of them. They're all frivolous. And then they'll give you an example. And the example will be frivolous. Like, it'll be outrageous. And you'll say, wow, that does sound like a terrible lawsuit. So there's my personal favorite is a guy who was an administrative law judge who sued his dry cleaner because he was unhappy with his pants. Okay, that's a lawsuit. I'm not going to deny somebody brought that suit. But for every one of those, how many are there that aren't even brought because people say, yeah, I know the doctor screwed up, but I don't want to bring any action against him because I like him personally, right? Mm-hmm. And how many times do you learn, or do you see on 60 Minutes, well, there was this doctor and he was doing these back surgeries. This is a real case. I don't talk about it in the book, but it was shocking to me. This doctor was doing these back surgeries for like 10 years, and he kept injuring people, and nobody brought a lawsuit. And it wasn't until somebody sued after this had been going on that the hospital said, you know what, you shouldn't be doing those surgeries in our hospital anymore. They injure people. They don't help people, right? So the interesting thing is the civil rights and torts are the hot button issues. Those are also the kind of cases that tend to be brought by ordinary people, right, who are not businesses. But that said, contract cases are also really important, because if you think about your life and when you enter into a contract with somebody, right, to fix your kitchen or your plumber or whatever, you're doing that in a background of knowing if something goes wrong, I have recourse. If this person is unlicensed and they do a bad job and they lied to me and said they were licensed or whatever the dispute is, I have somewhere I can go with that. It's not just, oh, good luck to you, right? And in other countries that have less developed legal systems than ours, that is not the case. So in China, I don't know what it's like right now, but as of 5 or 6 years ago, if you were injured in medical malpractice in China, you had no recourse at all. There's no court you could go to. So people would either protest outside the hospital, hoping that somebody would pay them, or in one case, the people were so mad that their child had been killed by the doctor that they went into the hospital and they shot the doctor. Or maybe they stabbed him, I can't remember what they did, right? But that's what people resort to when they have no voice, when they feel like there's nowhere for me to go with, something terrible happened to me, and there's no one who is not captured by the, governing interests that will listen to me. We don't want to be, we're not even close to that level, right? But we don't want to be in that position. We don't want to be a country that doesn't have laws where people can violate the law with impunity and, not take their obligations seriously. And so contract cases, just as much as any other, are about laying that foundation that says, no, you can't run over pedestrians without having to pay for it. No, you can't injure people. You can't just walk away from your obligations. These are all important values that we share. But I do focus more on the hot button topics because people are really upset about the tort system, even though tort filings have been significantly declining, even though the studies show that very few people who are injured actually bring any action. And you can see why. It's a big deal to bring a lawsuit. It's not easily done. You have to find a lawyer. You have to be willing to be deposed. These are all costs that you have to face.
Looks like we have some questions.
Yes, we do have questions. We have about 10 or 15 minutes to do questions. And so let's see. So the first one is, what role do journalists play in advancing and boosting the virtues of litigation? How can they do a better job than they are doing now?
That's a great question. I mean, and this is another thing where I think I have, as a litigator over the years, grown to appreciate how important it is, as a litigator who's doing public cases, to develop relationships with reporters and to see them as a really critical part of the process. If you think about this, if the purpose of a lawsuit is more than just, what happens within the four corners of the lawsuit, if it's about the way, future cases might be affected, the way what people think about what happened in the case matters as much as what happened in the case. It's like if your lawsuit is like a tree that falls in the forest and no one knows about it, isn't going to have much impact. And so it's so crucially important. Maybe this is just obvious, but it's so crucially important to, when you're framing the case, to think about, how it's going to be received in the press. We do things like, in the Emoluments Clause case, for example, we didn't want people to be making fun of our case right out of the bat. It made a big difference that when the case, the day before the case was filed, the New York Times ran an exclusive story, and you had the Supreme Court reporter for the New York Times and a really good reporter, Eric Lipton, who wrote this great piece, and they didn't make fun of us. And, I think that helped drive the conversation. I mean, we really were worried about being, think about it, we were invoking this clause of the Constitution that, nobody had heard of, suing the president, and, we wanted it to be taken seriously. The whole point was to have, to animate a constitutional conversation around this. So I think journalists have such a critical role to play. I think it is really tough. A lot of my friends here in DC are journalists. It's a very tough time to be a journalist. You're being attacked. Public confidence in the profession is at an all-time low. The government is attacking you, and the news cycle is just insanely exhausting. I mean, it's exhausting for us as consumers of news. It's even more exhausting to be a producer of it because you have to be on top of all of it. But I think, what can they do better? They can read the damn stuff. I mean, it's like when the Muslim ban litigation was going on, I was shocked at how BuzzFeed was the one place that was doing consistently good coverage, because they actually had a reporter who read the papers and formed views about them, wrote about them. So I think having more legally literate journalists is really important. There's a program that sends journalists to law school so they can do the first year of law school and report more intelligently about legal topics. I think things like that make a big difference.
And I talk to a lot of journalists, sort of, explain, sometimes you'll have a really complicated lawsuit or some ruling where it's hard to ferret out, is this significant or insignificant, right? And a lot of times they'll call me and I'll have, even background. They don't always quote me. It's just a background conversation about, why is this lawsuit in this court and not in some other court? And is this going to influence anybody else, or is this just a one-off, questions like that. And you see that especially in mass torts, which relates really profoundly to women's issues. So a lot of mass tort cases are about medical devices that injure women. And you'll have a trial, and the question is, well, what's that trial going to mean for all the other plaintiffs who were injured by this product? And so, there's a lot of conversations that can be had. I just want to say one other thing, which is, if any of you saw the movie Spotlight, so if you haven't, you should see it. It's such a great movie. But one of the things that happens in that movie that I've seen happen in a lot of cases is that the journalists found a way to get the information that had been produced in discovery, and then were able to publicize it. And that's a really important role for journalists that I think they're they do really great work very often, finding information that would otherwise be buried in a lawsuit. And in the DuPont case that I mentioned, which had to do with this chemical C8 that was in Teflon, it was, all of this stuff came out in a lawsuit, but I don't know if you guys even paid attention to it when it came out, but the regulators didn't pay attention until the press picked it up.
Yeah.
And it was published first in the local press in the area where people were getting cancer, and ultimately in the national press. And that made a huge difference in terms of the company's reaction, because the company realized, this is a giant reputational problem for me, and these reporters keep reporting on it. I need to do something to show that I'm a good citizen. And so they play a really important role in disseminating not just all kinds of information that comes out in lawsuits.
Don't a lot of the values you attribute to litigation, particularly about identifying good or bad reasons for something, rely on the assumption that there is a critical mass of well-informed, rational citizens? And is that a fair assumption?
That's a great question, too. So I really have to say, I'm a firm believer in the American citizen. And I know that, there's been a lot of, and bad feelings about different kinds of people. I even heard somebody say on the radio, a Trump supporter said, 50% of America might as well drop off the face of the earth as far as I'm concerned. I was like, oh, that's sort of not a nice way to think about, your fellow man. There's lots of vitriol on politically on all sides. And we do have an education problem in this country. That is, many people aren't receiving the education they deserve. And it's a problem when it comes to understanding difficult arguments. On the other hand, I've been really impressed in my own practice anyway. I did police misconduct and First Amendment retaliation cases. And one of the hardest things was actually people have a sense of what their rights ought to be, and it doesn't always match what rights the courts will actually recognize. And that's a really hard conversation to have. But that's not a hard conversation to have because they're not smart or they're not knowledgeable and they can't be educated. It's a hard conversation to have because it's a little scary how what you think you're entitled to from I guess the propaganda that's out there. I don't know where people get ideas about what their entitlements are, and what in fact, how limited our ability to either enforce our rights or the treatment of us. So I'm thinking of one young woman that we represented who had been strip searched in her school, and we were able to get a good settlement for her. But today, that's permissible. The Supreme Court said that they could do that, and that's horrifying, and that's a right that I think people, if they heard, wait, a school can do that, they would be shocked. I think. I mean, maybe you guys are, more salty than I am, but I find that to be very upsetting that can happen. And so there is an education process that's part of representing people and part of bringing lawsuits, but I sort of see it as part of our national conversation that we're trying to have.
Well, I mean, the question was whether the values you're identifying depend on having an informed citizenry. You see these values as ultimately about their democracy promoting values, right? I mean, democracy depends on having an informed citizenry, right? And the problem right now is we're not sure we have it. And we're not sure that they're getting the news that they need, or that they're
right. That's really very scary.
That it's not all channeled in particular ways that are predetermined, and whether we're a country that has a common set of facts. Barack Obama said that democracy needs a common set of facts, and if we don't have that, it doesn't work. I don't know that litigation can solve that problem. I mean, sometimes it can, like in the gay marriage example I gave, or the national security arguments about the Muslim ban, but litigation is too small a tool to fix that problem.
Okay, we have time for one more question, so you have to give me relatively quick answers to what I'm sure is not a simply answered question. How can we do a better job of empowering citizens in the legal process without lawyers as gatekeepers? This is going off of Deepak's point about the importance of combining movement and litigation, but going a step beyond that to find a way to allow marginalized citizens a greater voice in the legal process.
Yeah, I mean, it's a great question. I see someone here from an organization that I'm working with on a case right now that makes me think of this this question. We're representing some folks in a community organization. They're mostly immigrant workers, and there's a terrible accident, and it's very important in a case like that to make sure that everyone feels that they have a voice and is involved. And it's so great to have a case where it's both a class action and a community organization, because you can see it's like a public interest seminar come to life, this case that we have together. And we're involving them in the decisions. I mean, talking to these people about if you have to interpret it into their languages, you interpret it into their languages. But if we can't explain a strategic decision in the litigation in a way that they don't understand, that's our fault, not theirs. And you can do that. But I have to say that that's the exception, not the norm. And we're really fortunate that we have this structure to be able to do that. It's often just not possible. And the reality is, this is too long an answer, I'll stop. That class actions sometimes are kind of lawyer driven by nature, and I think that's okay sometimes too. It depends on the case, right?
Last week I was with some federal judges, and we were talking about this very issue, because they said, these lawyers, they come into my courtroom and they don't bring the client. So, what they were saying, Lahav, you have this participation idea, but I'm not seeing it in my courtroom because people aren't bringing their client. And I said, well, do you tell them, hey, can you bring your client? And they're like, no, that'll be the first step,
It's a pretty easy solution.
And they said rightly, look, for a lot of people to take a half day off of work to come to court is a big deal, and we don't want to make people feel that they have to do that. And I said, well, you could make it optional, you don't have to mandate it. But it might be interesting if the lawyer feels a little pressure to bring the client. And so I just want to say one more thing to this point, which is there's some really interesting work being done on how to help people proceed on their own. So the biggest problem probably facing the justice system is that most people can't afford a lawyer. And so when they bring a case, if at all, and very often they have to for various reasons, they have to represent themselves, and they're at a real disadvantage, especially if their opponent is an institution that has a lawyer. And there's some really great work being done on, is it possible to empower people to produce legal arguments on their own without a lawyer? And there's issues with the bar, that is, some of these things that people are trying to do run afoul of bar limitations that I think are going to be changing in the next few years, and you all, to the extent there are students in the room, you all can be a part of that. But there's really interesting work being done, and they give people materials and they observe them through the process to see which materials give people better outcomes and make people feel satisfied with the process that they got, even if they don't have a lawyer. Because the reality is that, we may have a lot of lawyers in the United States, but as it turns out, we don't have enough who are willing to do the work at the price that ordinary people are able to pay. So we have to find some other way to give people a chance to have their day in court. And so there's really cool stuff. If people want to talk to me afterwards, I can tell you some of the programs that are out there.
Well, that is all the time we have for this evening. Please join me in thanking our guests, Alexandra Lahav and Deepak Gupta. Thank you so much. Thank you. We are now hosting a reception, and everyone is invited. We hope that you join us. We were not able to get through all of the questions, so for those of you with burning questions that did not get answered or did not get written down, now is your time. So Chanel is going to take our guests to the reception, and then we will all follow along. Please join me again in thanking Howard University School of Law and Carmia Caesar in particular for making this evening possible. Thank you so much. And thank you to all of you who joined us here tonight and virtually. It was my pleasure and Teddy's pleasure and the Impact Fund's pleasure to host us tonight. Thank you so much to everyone.
Including a viewer from Nairobi, Kenya.
We have a viewer from Nairobi, Kenya tonight. So your reach is now global. Thank you all and good night.